The Supreme Court has ruled that Family First does not qualify for charitable status. After a legal fight which lasted almost a decade, the court ruled that expressing a viewpoint was not an automatic disqualifier, but that charities must genuinely seek to educate rather than to solely advocate for a political position. I sat down with Family First Chief Executive Bob McCoskey and asked him for his reaction to the ruling.
Well, we obviously disagreed with it vehemently. We think they've got it wrong. And I think most people that have contacted us about it are concerned about it, and simply they're questioning the consistency, because what the court said was that our education attempts had veered into advocacy, and therefore we were pushing a view, and they didn't think a charity should do that. But my question back to them and to people who perhaps are applauding the decision is, well, Greenpeace presented a 100,000 petition on Thursday at Parliament. That's advocacy. They're pushing a view. The Helen Clark Foundation and the Drug Foundation were promoting legalisation of cannabis while we were opposing it. They were pushing a view as well. So I think our concern is that it's not fair, and simply we need to be consistent about whether charities can do political advocacy.
The question isn't necessarily whether they can do advocacy, it's what that advocacy is informed by, isn't it? And I know the Supreme Court said that Family First advocacy is not fair, balanced or respectful. Now, I'm going to ask you about those education points in a couple of minutes, but is there any way for you to regain your charitable status?
Well, can I just answer that claim? That was made by one judge of five. Four judges did not make that statement, and we reject that because we believe that in the debate we have been respectful. People will disagree with what we say, but this is part of public debate. You often don't like people's views, but that's if our argument is so weak that we can't have the dissent, then we probably need to go away and work on our argument again, don't we? Because we need to be able to have that melding of ideas. And look, Sue Barker, the charities law expert, she said that we've been penalised not for breaking the law. We've been penalised for entering the democratic process. Now, most people see that as unfair. Yeah,
well, we've got you here so that you can express your views, and we're interested in hearing those arguments. So again, is there any way for you to regain that charitable status?
No, that was the end of the line in terms of court processes. 10 years, it's cost us about $750,000 because we've been fighting this on the basis that the danger is that when the court determines what can be and can't be said by charities, we're in a dangerous place.
Okay, now you talked about Greenpeace and those other organisations, the Helen Clark Foundation and the Drug Foundation, by matter of comparison.
And look, can I clarify that we're not saying that they should be deregistered. I actually think they should be registered. I think we just want a level playing field.
Okay, and let's talk about that, because there is an interesting distinction when it comes to that point around education. And the Supreme Court said that you can be a charity if you show that you are providing some sort of educational value. So when compared to Greenpeace, who went through a similar process to have their charitable status affirmed, the Supreme Court found that Greenpeace had, quote, independent scientific research, objective, neutral and balanced, based on industry standard modelling techniques, and was peer-reviewed by an appropriately qualified independent person. Thus, the means by which education was said to be advanced was demonstrably unbiased and neutral, and we do not consider this can be said of much of the material on which Family First relies in this case. And I've been through your website, I've been through the bits that say research, and it's clear that there isn't much peer-reviewed, robust academic literature or research that you have been publishing. So there is quite a clear distinction with Family First and Greenpeace on that argument.
Well, we actually put some evidence up, and it was put up by Professor Paul Moon from AUT about the whole peer review process, because what we actually found was that many charities publish research. They basically present their ideas, they present the research that backs up that view. And not all of it is peer reviewed. But see, I found that comment by the
Greenpeace
court.
was, though. That's the argument, though. Greenpeace does have. I mean, this is what the Supreme Court's saying, right?
If you can persuade me that Greenpeace isn't pushing a view, then
that's not the argument. No. I think we all agree that Greenpeace is advocating, but the point is whether or not Greenpeace is relying on robust, independently reviewed research, and the court found that Greenpeace is, but that Family First isn't. And from having been on your website, I can't see any evidence that would argue that.
No, well, that's up for debate whether their research stands up to scrutiny. For Greenpeace. In our case, I found it a slight, because our reports had been written by people such as Professor Rex Ardar at Otago University. It had been written by Australian bioethicist Dr. Gregory Pike, by a UK psychologist expert, Arik Sigmund, around screen time and around childcare. And even Lindsay Mitchell, who's a... Yes, they were reviewed, but it's how you define peer review. Because the thing is, we had experts in the field who reviewed the papers, but peer review is when you publish them in a journal. And so we had them checked. But I tell you what, Jack, nobody has actually challenged the factual basis of what we're saying. They've simply challenged the view that comes from those reports.
Right. Well, I'm just going from the Supreme Court argument, and one of them is that to be a charity, you have to have this educational standard, and that's the distinction that's been found. And I'm just saying, from having been on your website, a lot of the stuff under the research folder on your website is like you making videos and that sort of thing, as opposed to peer-reviewed, robust peer-reviewed industry standard research. The other point...
You might not have looked at the right...
well, I looked at research. I looked at research, so I don't know where else to look.
But
hang on, let me ask the second point, because the second point that was argued in the Supreme Court was about the benefit to the community.
Yes.
And I know you will have seen on page 49 of the Supreme Court's decision, they said family first purposes are themselves discriminatory. And I know that that is an inflammatory term, so I wanted to throw it open to you. How would you define discrimination?
Well, discrimination, I mean, they said we're discriminatory because we believe marriage is one man, one woman. Now, during the marriage debate in 2012, 2013, the politicians said, and I've actually just published a video last night, saying that the politicians promised that a view of marriage as one man, one woman would not be treated as discriminatory. They promised us that. So they haven't delivered on that promise. Now, the problem in the judgment... So
hang on, how do you define discrimination?
Well, the danger is that discrimination, I mean, it's $1 million question. What is discrimination?
What do you think?
Discrimination? I think it's when you disagree with someone's opinion. And so you prefer another one, so you discriminate one against the other. When I go into a supermarket, if I choose Pepsi or Coke, I've discriminated against one or the other. So
do you accept then that on that issue of marriage that the Supreme Court raised, your position distinguishes people and assigns different rights to people depending on their sexual preference?
No, we've always argued that marriage has always been defined through culture, through history, through millennia, and by much of the world still as one man, one woman. And we've said that if other people... Hang on, no, yeah, it does. But if people want to have their own relationships in different forms, that's fine. Use another name.
Okay, so do same-sex couples, under your definition of marriage, have the same rights as a man and a woman getting married?
Well, they have under the law. We're simply saying that we're coming from the perspective that marriage is one man, one woman. Family First has never backed away from the fact that we back a Judeo-Christian value, and that is that marriage has always been defined as one man, one woman. There are other forms of relationships. Use another name. That was our argument during the marriage debate. It was never a personal attack. It was simply saying there is a definition that we want to stick to.
So if the Supreme Court is concerned about defining discrimination and whether or not your organisation benefits the community, or whether or not by discriminating your organisation doesn't necessarily benefit the community, might they not focus on that distinction? Might they not focus on the fact that under your definition, same-sex couples don't have the exact same rights as a man and a woman who want to be married?
Well, see, I'm not quite sure what the point is, because you are always going to have different views of relationships that work. Our argument has been... I'm saying
yours is absolutely an argument that's held by many people around the world, and no doubt a large portion of New Zealanders as well, if not the majority. All I'm saying is that under the legal definition, it could be considered discriminatory, and thus that second argument before the Supreme Court doesn't stand up.
Yeah, it could, but the problem with the judgment was that they said that our view on marriage and family wasn't acceptable, was discriminatory, even though the politicians promised us that actually it wouldn't be deemed to be discriminatory.
You shouldn't trust a politician.
That's right, you shouldn't. But the other problem is that the court said that if we had been focused on environmentalism or human rights, as per the Greenpeace case, we would have qualified.
So who does an argument for environmentalism discriminate against?
Well, you discriminate against the forms of environment you want, and I tell you what, Greenpeace. Some people love Greenpeace because they agree with the environmental approach, and other people don't like Greenpeace because they disagree with the economic harm that the environmentalism policies are doing. Okay. So that's discrimination as well. Greenpeace are discriminating because they're saying we want to go down one path, we want to get rid of utes and gas guzzlers. So that's discrimination as well.
Okay. If that's discrimination, though, we can go back to the first argument in the case of Greenpeace and say, well, Greenpeace is, in the eyes of the Supreme Court, the educational opportunities that they offer stand up in a way that your organisation... These are the views of the Supreme Court.
And the Supreme Court holds that the religion of environmentalism is okay. But values around family and marriage are not okay, and that's what I warn is the disturbing part of the judgment. But we won't back off from those views.
Yeah, did you get a lot of donations after the decision?
They piled, and I think a lot of, well, some people said that when they donated to us, it was giving the two fingers to the government for deregistering us.
I want to highlight a comment that was made on Twitter by Dewey de Boer, who's was a new Conservative activist candidate and is a right-wing blogger. I'm interested in your thoughts on it.
Yeah.
Dewey said that the charity decision meant a good day for Christian nationalism, untethered from legal restraints on political activity. The real work can begin. And I wondered if that reflects your view.
No, I'm not quite sure what he means by that, because for Family First, even though we're underpinned by a Judeo-Christian value, I've worked in tandem with other faiths, Muslim faiths, during the cannabis referendum, during the euthanasia referendum, during the abortion debate. We've held hands with other faiths and non-faiths as well.
Does it free you up, though?
Not being registered? Absolutely, because there was always this fine line about whether you were doing too much political advocacy. And so I think, we were worried that we were overstepping that mark. But then again, we were looking at other organisations, other charities like SAFE and like Amnesty International, and there's a whole lot of them who I think should be registered, because I think if you're non-profit, you represent a constituency of the population, and you're entering the public debate. Let's have those social debates.
That is Family First CEO Bob McCoskey. Now, a quick note, Bob contacted us to challenge the quality of Greenpeace's independent research after the interview compared to Family First's. He pointed to an earlier judgment by the Charities Board which criticised some of Greenpeace's research and said they both have the same quantity of court-recognised, peer-reviewed research. But as I said in the interview, the Supreme Court ruling this week, whether you agree with it or not, was unequivocal in comparing the organisations. It said the material Family First presented did not meet the same standard as Greenpeace in advancing education.